This recorded lecture covers Chapter 5 on Ratification of Unauthorized Transactions. Up to this point in the course, we've looked at the various ways in which one person acquires power to bind another person to a transaction. As we've seen, a person acquires power to bind if the person has actual authority, apparent authority, if the doctrine of estoppel applies, or if the person has inherent agency power. In this assignment, we consider how a principal can become bound to a transaction when another person purports to act for the principal, but in fact has no power to bind the principal, because none of the doctrines we've considered so far applies. Let's go ahead and take a look at the case on page 115 in the casebook, Botticello versus Stefanovitz. In the Botticello case, the plaintiff, Botticello, negotiated for the purchase of a farm owned by the defendants in this case, Mary and Walter Stefanovitz, who were husband and wife who owned the farm as tenants in common. We're told that throughout negotiations, Mary said that she would not sell for the price that the plaintiff offered. The plaintiff and Walter ultimately entered into a lease agreement, and that lease agreement granted the plaintiff an option to purchase the farm for $85,000. Mary was not a party to the agreement. The plaintiff took possession of the farm and made substantial improvements to it. The plaintiff then notified defendants that he intended to exercise his option to purchase, and when he did so, the defendants refused. The plaintiff has brought this action seeking specific performance of the option and also damages. The trial court in this case held for the plaintiff on two theories. The first is that Walter acted as Mary's agent and therefore bound Mary to sell her interest in the property. The other theory on which the trial court held in favor of the plaintiff is that even if Walter had no power to bind Mary to the contract, she became bound because she ratified it, and specifically she ratified it by her subsequent conduct. Now, let's deal with that first theory, that Walter acted as Mary's agent. According to the Connecticut Supreme Court, Walter did not act as Mary's agent. There was no evidence that Walter was acting on behalf of Mary in the negotiations and the transaction with the plaintiff. So the mere fact that Mary and Walter are husband and wife and tenants in common does not mean that one is the agent of the other. This means that if Mary is to be bound by this lease, which contained the option to purchase, it must be under the second theory that the trial court applied, which is that Mary ratified the lease by her subsequent conduct. Let's consider what it means to ratify a contract. In the Restatement Third of Agency, ratification is discussed in Section 4.01. Section 4.011 says that ratification is the affirmance of a prior act done by another, whereby the act is given effect as if done by an agent acting with actual authority. So, in other words, if a person ratifies a prior act that another person has done, then we treat the situation as if the act had been authorized from the very beginning. We have some further guidance in Section 4.012 of the Restatement Third of Agency, which says a person ratifies an act by either manifesting assent that the act shall affect the person's legal relations, or by conduct that justifies a reasonable assumption that the person so consents. Finally, let's consider Section 4.03 of the Restatement Third of Agency, which says a person may ratify an act if the actor acted or purported to act as an agent on the person's behalf. Let's go ahead and apply these rules to the Botticello versus Stefanovitz case. In Botticello versus Stefanovitz, the court concludes that Mary did not ratify the lease agreement into which Walter had entered. Recall that Section 4.03 of the Restatement Third of Agency says that a person may ratify an act if the actor acted or purported to act as an agent on the person's behalf. In this case, Walter did not act or purport to act on Mary's behalf in entering into the lease agreement with Botticello, and for this reason, Mary simply could not have ratified the lease agreement. On page 117 in the casebook, the court says in the very first paragraph, since Walter at no time purported to be acting on his wife's behalf, as is essential to effective subsequent ratification, Mary is not bound by the terms of the agreement, and specific performance cannot be ordered as to her. Even if Walter had acted or purported to act on Mary's behalf, Mary had done nothing that would constitute ratification of the lease agreement into which he entered. Recall that Section 4.012 of the Restatement Third of Agency says that a person ratifies an act either by manifesting assent that the act shall affect the person's legal relations, or conduct that justifies a reasonable assumption that the person so consents. In this case, Mary had not manifested assent that the act shall affect her legal relations, so the question becomes whether she engaged in conduct that justifies a reasonable assumption that the person so consents. Comment D to Section 4.01 of the Restatement Third of Agency says that a person may ratify an act through conduct justifiable only on the assumption that the person consents to be bound. In other words, for conduct to constitute a ratification, it must be conduct that is explainable only if the person is choosing to be bound by the transaction in question. Here, the plaintiff Botticello argued that Mary's conduct that constituted ratification was accepting the checks that he had sent representing the rent payments. The court here concludes, however, that her accepting the checks representing the rent payments was not conduct that justified a reasonable assumption that she consented to be bound by the lease agreement. Why not? Because her accepting those checks is fully consistent with Walter leasing out his undivided 1/2 interest in the property. Therefore, that is, her accepting the rent checks is not conduct justifiable only on the assumption that she is choosing to be bound. Because Mary did not ratify this contract, she is not bound by it. Walter, however, is bound by it, and the court remands for further proceedings on the remedy to which Botticello is entitled. Let's consider the two ways in which a person can ratify, according to Section 4.012 of the Restatement Third of Agency. We just considered one of them, conduct that justifies a reasonable assumption that the person so consents. The other possibility is the principle manifesting assent that the act shall affect the person's legal relations. Now, a manifestation of assent could be any type of communication or manifestation from the principal, such as an express statement that they consent to be bound. The point I want to emphasize is that the manifestation of assent need not be communicated necessarily to either the agent or the third party. So, as an example, suppose that The day after Walter and Botticello sign the lease agreement, Mary writes in her diary, "Walter shouldn't have entered into the contract without my permission, but I'll go along. The extra money will come in handy." And let's suppose that Mary dies that night. Well, in that case, her estate likely would be obligated to convey her interest to Botticello if he chooses to exercise his option to purchase. So the point is, the manifestation of assent by the principal need not necessarily be communicated to either the agent or to the third party. Let's consider 3 points related to ratification. The first is the issue whether an undisclosed principal can ratify a contract. This issue is discussed in the casebook in Note 2 on page 117. The Restatement Second and the Restatement Third adopt different positions on this issue. The Restatement Second, in section 87, says that in order for a principal to ratify, the agent must purport to act on the principal's behalf. In other words, the agent must appear to be acting on the principal's behalf. And for this reason, the agent of an undisclosed principal does not purport to be acting for a principal, and therefore an undisclosed principal, in the view of the Restatement Second, cannot ratify a contract. The Restatement Third, in section 4.03, states that a principal can ratify an act if the agent either acted or purported to act on the principal's behalf. In other words, even if the agent does not purport or appear to act on the principal's behalf, it's enough if the agent actually did act on the principal's behalf. And for this reason, an undisclosed principal can ratify a prior act of an agent. Recall that the restatements are attempts to state the common law of agency in an organized way. We see here the different views of the drafters of the Restatement Second and the Restatement Third on the common law of agency on this question. The prevailing view for many years, as reflected in the Restatement Second, has been that an undisclosed principal cannot ratify a contract. The Restatement Third, we note, takes a different position on this issue. The second issue is the principal's capacity to ratify a contract. This issue is discussed in the casebook in Note 1 on page 117. According to the Restatement Second of Agency, section 84, in order to ratify a prior act, the principal must have been able to undertake the transaction both at the time the agent entered into it and also must be able to undertake it at the time of ratification. So, as an example, suppose that at the time the agent entered into the transaction, it would have been illegal for the principal to enter into that transaction. In that case, the principal could not subsequently ratify it because it was not a transaction the principal could have undertaken at the time the agent acted. The Restatement Third, in section 4.04, takes a different position. It states that the principal must have been in existence at the time the agent enters into the transaction and must have capacity to enter into the transaction only at the time of ratification. In other words, it's enough that the principal existed at the time that the agent acted, and the principal must have been able to undertake the transaction only at the later time of ratification. So again, with that same example, suppose that the agent enters into a transaction that it would have been illegal for the principal to undertake. Well, the Restatement Third suggests that the principal could subsequently ratify that transaction, assuming that at the time of ratification it was no longer illegal for the principal to enter into that transaction because all that's required is that the principal was in existence at the time that the agent acted. And in this case, that is true. The principal existed, and as long as the principal can undertake the transaction at the time of ratification, then the principal is bound through ratification. This same issue comes up in the corporate area. In the corporate area, we encounter a situation where a promoter is forming a corporation, and before the corporation is in existence, the promoter will enter into agreements on the corporation's behalf. Perhaps the promoter will lease some space for the corporation to use for its business before the corporation is actually in existence. Well, under either of these formulations, from the restatement second or the restatement third, the corporation could not subsequently ratify that lease. Why not? Because the corporation was not in existence at the time the lease was entered into. The final point is that a principal can create apparent authority for future transactions by ratifying a transaction. So, for example, suppose that an agent enters into a contract to sell the principal's goods to a third party, and the agent has no authority to enter into that transaction. And suppose that the principal ratifies what the agent has done by manifesting assent to be bound. Now let's suppose that the same agent enters into the same sort of contract to sell the principal's goods with a different third party. And that different third party is aware that the principal went along with the first transaction. Well, by ratifying that first transaction, the principal may well have created apparent authority as to the second transaction. Recall that to have apparent authority, we need a manifestation of the principal that causes the third party reasonably to believe the agent is authorized. By ratifying the first transaction, the principal makes a manifestation to third parties that could cause them reasonably to believe the agent is authorized as to future transactions. The key is that this occurs when the principal ratifies without communicating to the third party or to other people that this was unauthorized transaction, but the principal is choosing to ratify it. So, for this reason, when a principal ratifies a transaction that was unauthorized, the principal really should communicate to the third party that this was unauthorized conduct and the principal is choosing to ratify. If the principal does not do that and simply goes along with the contract, then the principal is making a manifestation that may lead other third parties to believe that the agent, in fact, is authorized. Let's take a look at problem 5.1 on page 115. In this problem, we're told that Alan leases Paula's farm to Terry for a term of 5 years. Alan, we're told, purported to represent Paula, but has neither authority nor power to bind her. Alan then tells Paula what he has done, but does not tell her about the term of the lease. Paula does not inquire about the term of the lease, and she demands and accepts from Terry the security deposit and first month's rent. In part A of the problem, we're asked whether Paula ratified the lease. Well, if we think about the circumstances here, she did ratify the lease. Her act of demanding and accepting the security deposit and the first month's rent is ratification by conduct that is justifiable only if she is choosing to be bound. In Part B of the problem, we're asked, can Paula avoid the lease after she learns that the term of the lease is 5 years? And then we're asked, would there be any difference if the terms of similar farm leases customarily range between 3 to 5 years or 1 to 3 years? Well, if the customary term of the lease is 3 to 5 years, then Paula should not be able to avoid ratification of the lease. However, if the customary term of farm leases is 1 to 3 years, then in that case, Paula may be able to avoid it. We have some guidance on this in Restatement Third of Agency, Section 4.06. This issue is discussed in the casebook in Note 4 on page 119. The guidance is that a person is not bound by a ratification that is made without knowledge of any material fact involved in the affirmed transaction. So, in this case, if Paula affirmed the lease into which Alan entered without knowledge of a material fact, then she can avoid her ratification of the contract. The question becomes, what are material facts? The Restatement Second of Agency said this, that material facts are those that substantially affect the existence or extent of the obligations involved in the transaction, as distinguished from those which affect the values or inducements in the transaction. The Restatement Third does not contain a definition of material facts, and instead refers the reader to the definition of material facts in the Restatement Second of Torts, Section 538. Restatement of Torts, Section 538(2). And there, we're told that a matter is material if a reasonable person would attach importance to its existence or non-existence in determining his choice of action. Well, if we think about these definitions of material facts and apply them to our case, the term of the lease should be regarded as a material fact. It substantially affects the existence or extent of Paula's obligations involved in the transaction. So, therefore, Paula should be able to avoid her ratification of the lease if the customary term of farm leases is 1 to 3 years. As we've just discussed, material facts are those that substantially affect the existence or extent of the obligations involved in the transaction. In contrast, facts that affect the values or inducements involved in the transaction are not material. Let's consider two examples. In the first example, we're told A, who has no power to do so, enters into a contract to sell the principal's goods, and tells the third party that the principal will buy the goods back within 1 year if the third party so desires. The agent does not tell the principal of the buyback provision, and the principal then affirms. In this case, the principal can rescind the affirmance upon learning of the provision. The buyback provision is a material fact of which the principal was unaware at the time the principal ratified the contract. In the second example, A, who has no power to do so, contracts with a third party to sell the principal's shares in a corporation. The principal then affirms. After affirming, the principal learns of a recent development that makes the shares much more valuable. In this case, the principal cannot rescind the affirmance. The recent development that affects the value of the shares is a fact that affects the values or inducements involved in the transaction and would not be regarded as a material fact of which the principal was unaware. Let's take a look at assignment 5B, which deals with knowledge of agents and its role in connection with ratification by principals. Let's take a look at the case on page 121 in the casebook, Estate of Sawyer versus Crowell. In this case, the principal is an estate, the estate of Sawyer. The agent acting for the estate is Durrance, who is an attorney and also administrator of the estate. And the third party is an individual named Crowell. We're told that Durrance, the attorney representing the estate, needed to invest the estate's funds and agreed with Crowell, who is the defendant in this case, that Crowell would invest the funds in high-grade commercial paper due in 6 months. Durrance, at that time, specifically ruled out investing the funds in the Vermont Real Estate Investment Trust, or VREIT, which is a real estate investment trust of which Crowell was co-founder and sole manager. We're told that Crowell invested the funds in high-grade commercial paper that was due on August 12th. On August 12th, Durrance instructed Crowell to reinvest the funds in high-grade commercial paper on a 30-day rollover basis so that the funds would be available when the estate was wound up. Crowell, however, invested the funds in the Vermont Real Estate Investment Trust. Then, on October 14th, pursuant to Durrance's instructions, Durrance's secretary wrote to Crowell asking how to continue the investment and how much notice Durrance would have to give to withdraw the funds. Crowell responded the next day with a letter to the secretary that gave the requested information and also stated that the funds were invested in the Vermont Real Estate Investment Trust. Then, on December 31 of that year, after learning that funds of another client had been invested in the Vermont Real Estate Investment Trust, which was having trouble returning the funds, Durrance looked at the estate's file and saw Crowell's letter stating that the funds were invested in the Vermont Real Estate Investment Trust. Durrance immediately demanded the return of the estate's funds, but the Vermont Real Estate Investment Trust had filed a petition in bankruptcy. The estate then brought suit against Crowell for the funds on the basis that Crowell had materially breached his agreement to invest the estate's funds. Crowell argues in his defense that Durrance ratified Crowell's investment of the funds in the Vermont Real Estate Investment Trust. Recall that the effect of ratification is the same as if the transaction had been authorized from the beginning. So Crowell is arguing that because Durrance ratified what Crowell had done, then it is treated as if the transaction had been authorized from the very beginning. Crowell makes the following argument. First, that Durrance is charged with his secretary's knowledge that the funds were invested in the Vermont Real Estate Investment Trust, and second, that Durrance affirmed Crowell's action by failing to take any action to change the investment. So, in other words, Crowell's arguing that Durrance knew about the investment of the funds in the Vermont Real Estate Investment Trust because Durrance is charged with his secretary's knowledge that the funds were invested there, and that by failing to take any action to change things, Durrance effectively ratified what Crowell had done. The court responds by saying that a principal is chargeable with knowledge of an agent acting within the scope of the agent's authority. And the court concludes the secretary's knowledge
did not arise within the scope of her authority. Her only authorized conduct was to inquire about how to withdraw the funds. Now, recall when we talked about knowledge of agents, we said that a principal is bound by an agent's knowledge when the agent acts with power to bind, or when the agent has a duty to convey the information. We'd probably get the same result under the Restatement Second of Agency, Section 272, regarding attribution of the Secretary's knowledge to Durance. The Secretary did not act with power to bind Durance or the estate in this matter, and I think we'd also say that she had no duty to convey the information to Durance about investment of the funds because she was completely unaware of the significance of that information. So it would be difficult to say she then had a duty to convey it to Durance. So Crowell's argument fails in this instance. That is, his argument hinges on the Secretary's knowledge about the investment of the funds being attributed to Durance. Now, this case illustrates that a principal can ratify a transaction based on knowledge attributed to the principal through an agent. Here, that argument failed. However, if the Secretary's knowledge was attributable to Durance, then we would get to the issue whether Durance's failure to repudiate what Crowell had done constitutes ratification. That is, does silence constitute ratification? Now, this issue is discussed in the casebook in Note 3 on pages 124 and 125. As indicated there, failure to repudiate a transaction can constitute an affirmance, depending on the circumstances. The authority for that is Restatement Second of Agency, Section 94. Also in Note 3, we see a reference to Restatement Third of Agency, Section 4.01, Comment F, which says, a principal may ratify an act by failing to object to it or to repudiate it. Ratification results from a person's manifestation of assent. Failure to object may constitute such a manifestation when the person has notice that others are likely to draw such an inference from silence. There's one further issue we might explore here, and that issue is Crowell also an agent of the estate? And the answer is that Crowell is. Durance, acting for the estate, hired Crowell to invest the estate's funds. So Crowell is acting on behalf of and subject to the control of the estate. If that is the case, then the question arises, why isn't the estate, or Durance, charged with Crowell's knowledge that the funds were invested in the Vermont Real Estate Investment Trust? And the answer is that in determining whether a principal has affirmed or ratified, the principal is not charged with knowledge of facts relating to the agent's own unauthorized acts. This issue is discussed in the casebook in Note 2 on page 124. This concludes the lecture on ratification by principals.